The live stream will begin shortly. Please note that RapidVisa is not a law firm and is not licensed to practice law in any state. The hosts of the show are not attorneys. RapidVisa is a document preparation firm, licensed and bonded in the state of Nevada. We will do our best to answer informational questions during the stream based on our experience in helping tens of thousands of customers successfully apply for their immigration petitions. However, if you need legal advice, we advise you to seek assistance from an attorney. Please post your questions in the comments section during the stream for a chance to win a $100 RapidVisa credit towards a future service. Now, enjoy the show.
Welcome to RapidVisa Live. Once again, streaming live simultaneously on YouTube and Facebook. It's another beautiful day here in Las Vegas. Once again, we're offering a $100 RapidVisa credit towards a future service that we're going to select randomly from somebody who asks a question in the comments. So please put your questions there in the comment. We'll try to get to all of them. Many times we have more than we can get to. So the quicker you get it in there, the better chance you have that we'll get to it. I'm Ben, the founder and CEO of RapidVisa, and joining me today is Isela from our assembly team, and she's going to tell you about some news, and then we'll get into your questions.
Yes, the new public charge rule given green light by Supreme Court. You may remember back in August of 2019, DHS published its final public charge rule. The rule outlines stricter requirements, including disqualifying non-immigrants who use certain public benefits and also disclosing an income safe zone, which is above 250% the HHS poverty guideline. Several courts filed injunctions on this rule, which delayed its implementation. Well, the Supreme Court has reversed all but one of these injunctions, and the rule will go into effect February 24, 2020. What this means for RapidVisa customers: if you are applying for adjustment of status or a spousal visa after February 24 and you live anywhere other than Illinois, you will be subject to the new standards. DHS will not consider an alien's public charge benefits that were used or applied for before February 24, 2020. So if you have used benefits in the past, it appears they won't count that against you, and that they only consider benefits used after February 24, 2020. Officers will have new criteria in determining whether or not an alien is a public charge or likely to become a public charge. Factors that will be taken into consideration in the determination include the applicant's age, health, family status, assets, financial status, education, skills, and more. Heavily weighted negative factors include use of certain public benefits after February 24, 2020. The alien is authorized to work but hasn't been employed. The alien was diagnosed with a condition that could have an effect on the ability to provide for themselves, and aliens who were previously deported. If you have any of these heavily weighted negative factors, you are likely to be denied for public charge. Heavily weighted positive factors include alien's household income is over 250% above the poverty level, the alien is authorized to work and is currently employed, the alien has private health insurance. If you have any of these heavily weighted positive factors, you are unlikely to be denied for public charge. If you don't have any of the heavily weighted factors, negative or positive, you will just want to build the best possible case with the application, and that's one reason you should hire RapidVisa. You will face more scrutiny, but that doesn't mean you can't overcome the scrutiny.
Okay, so what I would say to kind of sum up the public charge issue is that, number one, it primarily has to do with the use of public benefits, but only by the alien. So if you are a U.S. citizen sponsor and say you're bringing your wife, your mother, your fiance, your child, or somebody here, it does not matter at all that you may have used public benefits at some time in your life or even now. That's not what this is about. This is about the alien. So if the alien is in the United States and has used public benefits after February 24th, which is unlikely right now, then you could be deemed a public charge. So past use of public benefits by an alien is irrelevant. If it's before February 24th, that doesn't matter. And any use of public benefits by the sponsor, the U.S. citizen, doesn't matter either. So while it sounds very scary, it's not going to apply to most people. Most aliens are not in the United States. Where it could apply is perhaps you're here maybe on a student visa you're an alien here on an F1 student visa, and then for somehow, some way you use public benefits, then that could be a problem. So for most people, this is not going to apply. So it's kind of a big deal, but it's kind of not. Obviously, it's a big deal if it applies to you, but it's going to apply to such a small number of people that I wouldn't lose a lot of sleep about it. Okay. A little more news is the Trump administration has added 5 new countries to the travel ban list. So, as you know, we already had 6 countries on the travel ban list, and sometimes people refer to it as a Muslim ban. That's not technically what it is, but just might help you understand or remember what we're talking about. So, the 5 new countries are Burma or Myanmar, Eritrea, Kyrgyzstan, Nigeria. You know, Nigeria is the one that's of the most importance to us because we do quite a few visas from that country, but also because it's the largest economy, largest country in Africa. That one, we suspect that they're working. Nigeria is working with the U.S. government to try and get that overturned. It appears, although there's not a lot of detailed information about it, appears that that's based on the United States' concern about the security that wraps around documents and passports and those kind of things. And if Nigeria can resolve those, we're hoping that that one will be will be lifted. So if you're in the situation of wanting to bring a relative here from Nigeria, our recommendation would be wait it out, sit on the sidelines, let's see what happens. Now, if you want to go ahead and file your paperwork, or you want us to go ahead and file your paperwork, we're certainly willing to do that. But obviously we can't guarantee approval because currently right now there is technically a ban for people from Nigeria. Now the question has come up, what if you're living in, say, the UK or somewhere else? Well, the determining factor is going to be what's your citizenship, which generally for most people means what's the name of the country on your passport. If you're a Nigerian citizen with a Nigerian passport, doesn't matter if you're living in Belgium or somewhere else, you're still going to be subject to this ban. Now, again, this is new, and we haven't seen cases coming through yet, so a lot can change, but we just wanted to bring you what we know about it. If you have currently a petition with RapidVisa in our office, but it's not yet been filed with the government, we'll contact you about that to see how you want to proceed. Otherwise, if you're a RapidVisa customer, or even if you're not, give us a call. We can't offer any legal advice. We're not attorneys, but we can tell you what we're doing with the paperwork and what we might think might be the best course of action.
Okay, and in other news, we have the U.S. temporarily halts China visa interview due to coronavirus. On Friday, January 31st, President Trump signed a proclamation barring entry to the United States of most foreign nationals who traveled to China within the 14 days immediately prior to arrival in the United States. The proclamation went into effect on February 2nd. This action follows the declaration of a public health emergency in the United States related to the coronavirus outbreak in Wuhan, China. The proclamation does not apply to U.S. citizens or lawful permanent residents of the United States. Furthermore, the U.S. embassies in China have postponed interviews for the time being. Applicants with pending interviews have been notified by the embassy directly. We will continue to monitor this outbreak and report on its effects on U.S. immigration as new developments arise.
Okay, on lighter news or good news, we have introduced a new payment plan. Our payment plan has proven to be very popular with our customers, and previously we did not have a payment plan if you were just going to purchase our most basic product. We were really doing the payment plan on our more robust packages. So, but now for the K1 Visa package, we have a $99 a month product. It's 6 payments at $99. That will get your K1 Fiancé Visa documents prepared. And then we have the similar program for if you want to do the combo where we have the K1 Fiancé Visa and the adjustment status. That one's $109 a month, but for 12 months. And we also have a new payment plan for the basic adjustment status at $119 a month, the spousal visa also $119 a month, and the child or parent visa $119 a month. So new payment plans for those of you who are interested in that, or that would be a help to you. We're happy to talk to you about that. Check it out on our website, rapidvisa.com, or give us a call, and we're happy to tell you all about that. Okay, it's time to jump into some questions. I'll let Sela take the first one.
Yeah, so we have a question from Steve Lee from YouTube. He's asking, does bankruptcy or debt consolidation interfere with the spousal visa? So at the moment the petition itself, obviously the first initial part, the petition process, this is not an issue. Now, when it becomes to the, proving your financials, at the moment it's also not a problem, to have bankruptcy or debt consolidation. Now, with the new updates, coming with the I-864 form, I'm not sure if we have seen any changes with debt and bankruptcy, but as far as the U.S. citizen, seems like this is not a question yet on that form. We've seen changes only for aliens about debt consolidation and bankruptcy.
Right. We have done a lot of cases of people who've had bankruptcy, and again, as Acela mentioned, there is this new public charge rule, but that really typically applies to the alien, right? So you as the sponsor, if you've had bankruptcy or debt consolidation, or even just plain old rotten bad credit, we've seen a lot of that through the years, and it's never been a problem. Now, things are changing quickly now, and there's a lot of pressure apparently intended to just reduce immigration overall, or reduce immigration of poor people. I don't know what the exact goal is, but so we can't say how things will go in the future, but what we can tell you is up until now, and including very recently, that has never been a problem if you, the sponsor, had a bankruptcy. What they're really concerned about is, can you support the individual right now today? So if right now today you have adequate income, you're going to be in good shape. It's been our experience. If you had a bankruptcy last year, 2 years, 10 years ago, debt consolidation, a 300 credit score, whatever, these things have never in the past mattered. Again, things are changing quickly in this area, but right now that's what we know. Okay, I'll take the next one. Is from Lopez. Says, my ex-fiance and I applied for a K-1 visa, but we broke up after we got the NOA-2. The NOA-2 is the USCIS approval. The process is still active, USCIS website. How can I cancel it? I'm the beneficiary, and I don't know which office has my case. Oh, okay, so you're the beneficiary. Well, this is a good question. Comes up occasionally. Unfortunately, all relationships don't work out. What you need to do is you need to write to the USCIS, the office. If it's K-1 visa, they all go to Dallas, to the Dallas lockbox. You can look on the USCIS website, go to the forms page. So it's uscis.gov/forms. Go there. If you find the I-129F, you'll see the address there. It tells the address where you mail it. That's the same address. And what you want to do is you want to send them a written notice along with the case number. So hopefully you have that case number. If you don't, then enter the names and dates of birth and all the information you can to help them identify and locate the case. However, let me say this. The petition is really filed by the sponsor, not the beneficiary. So we generally recommend that the sponsor submit the request to withdraw it, but you can also submit the request yourself and get that on record. Now, what'll happen if you don't? Let's say you can't find the case number, or they can't find your file, or they're unwilling to do it because you're the beneficiary and not the sponsor. It will just die its own death anyway once you stop responding to it. I mean, what'll happen is, now that it's approved, it's going to go by way of the NVC. It's going to go to the embassy, which you don't mention, but it's going to go to the embassy of that country where you're at, and they will send out a notice for you to attend the interview and all that. And when you ignore all that, it's just going to die. Technically, they have a 4-month expiration date. So from NOA-2, which the USCIS approval, expires in 4 months. Now, the embassies routinely extend that if necessary for the interview, which is often necessary. But when you don't respond, it'll just die. So there's nothing you have to do. It's not going to cause any problem. It's going to eventually get returned to the CIS, and it'll go away. But it is a good idea to send in that cancellation if you can.
Okay, and we go into the next question from YouTube, from Mimi Peralta. She's asking, I received an RFE in regards to a K-1 petition I filed in 2018. They are requesting supporting evidence along with the request for a multiple filing waiver. What can I possibly send if the relationship ended since then? So Mimi, if you are a customer, we highly suggest that you contact us, and we will ask you to upload this RFE letter to your account so we can help you with that. We obviously stay with our customers throughout the whole process, including RFEs. But yeah, supporting evidence and obviously if you have filed for more than one person within a certain time frame, you will need to write this letter. You're mentioning the relationship ended since then. I'm not sure if you're referring to the relationship to the other people you petitioned, or if it's about the relationship you currently have with your fiance. So yeah, just write us back maybe with additional information on that.
Okay, next question from Facebook. Samar says, how public charge rule won't affect petitions? Okay, so he's asking if it won't affect petitions before February 24th. So the public charge rule goes in effect 24th. If your petition is filed, and filed means they receive it and enter it into their system before February 24th, the public charge rule doesn't apply. However, even after that, they're really talking about benefits received on or after February 24th. So even after that, for a while, for practical reasons, it's not going to apply. But yes, any petitions that are received right now before the 24th, and currently any petitions where the sponsor, the U.S. citizen sponsor, is in Illinois, it doesn't apply. And the reason Illinois is accepted is because there's a separate court case there. But based on precedents, that case is probably going to go the same way the others did. In other words, the administration is probably going to win that. And so I would just assume if you're in Illinois, it is going to apply to you too, sooner or later. Judges don't generally overrule other judges' decisions, so I would expect that it's going to happen. So yeah, if you get it filed for 24th, you don't have to worry about it.
Yeah, and in addition to that, a lot of our customers, it does state on the website, on the USCIS website, that it must be postmarked before February 24th, but we highly suggest, that you obviously take the time to submit it way before that so they can actually receive it, not only be postmarked by that date or before that date, but actually, received by February 24, because it's up to the USCIS officer at the end of the day, and we've seen cases where they say, postmarked, but they actually consider the date that it was received. So.
Right, very good. And also it's really, right now what we're seeing is they're really applying this to the adjustment of status applications, and we're not seeing any changes on the process or the forms for I-130 type petition, which is a little gray area because with adjustment of status, many times you're also doing an I-130, but we're not seeing changes to those forms. So it looks like right now the target for that rule is more about aliens who are in the United States already, have been here for some time and use public benefits and are now trying to get a green card. It seems to be targeted at those individuals and not so much at somebody who's just bringing their wife here from overseas.
Okay, and we move on to the next question from YouTube, from Mimi Peralta. She's asking, what happens to a petition if it gets approved but nothing is done after that? So as Ben mentioned before, if a petition gets approved and nothing is done, there is actually a date on the notice of action, approval notice, and it's sort of like an expiration date. So if nothing is done after that date, even if they didn't give you a deadline, the case automatically closes. So it is obviously suggested that you or the petitioner closes the case if possible, but if that doesn't happen, it's automatically closed.
Okay, from Facebook, Izzy says, will the travel ban affect those that are waiting for an interview from the NVC? Okay, so we haven't received, unfortunately, real clear guidance on that point. I would assume, what the questioner is basically saying is, hey, already approved by the USCIS and we're at the NVC stage, which means basically you're dealing with the National Visa Center, and then you will be preparing for your interview. So we haven't received any clear guidance. I'm going to assume from a plain reading of the information that yes, it will apply to you. Now, the travel ban, the current countries that were just added didn't impact non-immigrant visas like a tourist visa or work visa. So if you're in one of those categories, it won't apply to you at all. But if you're a family visa immigrant applicant, then a plain reading would indicate, yes, it does apply to you. The reality of how it's implemented, unfortunately, lately in the last few years, things have really been unorganized and thrown together and thrown into law without much forethought. And so we're in an era where it's difficult to predict how it will be how it will impact people who are currently in the process. But a plain reading of it would indicate that it does apply. In other words, a plain reading of that particular rule, different than the public charge and the ban, it doesn't say people applying after this date. It just says they're banned. So I'm going to assume that that means immediately. And you know, as always with these kind of things, if you're willing to give it if you're willing, and well, you're already in the process, so I would say just go forward with it. You know, don't do anything. Wait to hear from them, and maybe you go right through, and maybe they will grandfather the people already in the process. Wish I had a better answer for you, but what I would say is you certainly have a right and to be nervous and worried about it, and I would be too. But I would proceed as if you're going to go through, and then see what happens.
Right, especially if you're at the interview stage already. I mean, there's really nothing to lose. You don't have any more fees or anything like that. So, yeah. Then now we continue to a Facebook question from Clay, who's asking, should I bring copies of every document I submitted with Form I-485 to the adjustment of status interview? So yes, we suggest that you do. Everything that you submitted with your adjustment of status application, including copies of the applications themselves, bring them with you. They actually give you a pretty detailed list when they send you the notice for the interview. So yeah, read through that list. It tells you right there to bring everything that was submitted. And sometimes they might refer back to those documents, and it's important to bring them. Also, it is suggested that you bring originals and copies in case they want to verify any documents.
Okay, and I'd like to take a moment to interject that we're not attorneys. It's not a law firm. So we're here. We get so many questions all the time. We started doing this video series, and we like answering your questions. But as always, remember, when you're doing some important process, especially something as critical as your immigration, it's great to go out and gather all the information you can from trusted sources, but don't make life-changing decisions based on a 60-second answer on an internet video. Use this information to point you in the right direction. Confirm it with other sources. Just be careful is what we're saying, because we can't possibly understand all aspects of your situation with a brief question that you posted online. So take the information, use it to keep you pointed or going in the right direction, but don't go making big, giant, life-changing decisions based on us or anybody else in a very brief question and answer session, because there are a lot of variables and situations that we may not fully understand or may not even be qualified to answer. So please, take it for what it's worth. Okay, from Facebook, Christy is asking, credit checks done for the beneficiary only, and is it after February applicants or all ones? Okay, so in the past they've never done credit checks, and in the future we don't have any clear guidance on whether they will or they won't. The public charge rule basically says that they may and can look at all information and make a determination of whether they think you will become a public charge. And of course, public charge is the government lingo for, are you going to end up on welfare? Are you going to end up on public benefits, and the taxpayer has to support you? So they're going to look at the totality of the case. And I mean, for instance, if your sponsor has a solid income, then you are less likely to be a public charge, right? There's no requirement, unless you're coming on a work visa, there's no requirement that you work when you get here. So, and there's no requirement that you have a great income. They're going to look at the totality of the case. So, it's in the United States, it's very easy to do a credit check, right? If you're an alien, that's not really the case. If you're in Philippines, there's no way to do a credit check on you. They don't have credit bureaus like we do here. So I wouldn't worry about your credit too much. Will they look at the holistic picture? Sure. If you've been in the United States for years on some type of non-immigrant visa and you have a credit record, sure, they may look at that. But I think just the fact that you may have poor credit is not going to cause you to be denied by itself. They're really looking at this whole picture, and can the sponsor support you? Is there an expectation that you're going to end up on public benefits? That's the goal. Now, having said all that, again, this is new. This whole public charge rule is new. It's not even in effect until February 24th of 2020. So we all are kind of waiting to see how strict the enforcement's going to be. until we start getting some feedback, which we will in short order because we do a high volume of visas. But until we do, there's really nobody who knows the answer to how strictly this will be enforced. With government rules and regulations, they are sometimes followed extremely closely and extremely aggressively. Other times, it's more of a guideline, and so we don't know where this one will fall. Will it cause denial in a lot of cases, or will it simply be used when in cases where the alien has been here for years already using public benefits? It seems to be targeted more towards that situation than new arrivals. So for most people, it's not going to be a problem. I probably wouldn't worry about it unless I have been in the United States for years on some other type of visa, student visa, work visa or something, and had used public benefits. If you're that person, I think that's who this rule is targeted for. So if you're that person, then yes, you may have some work to do to overcome objections. If you're not that person, you're probably going to be fine. Okay, it looks like we lost our feed here just for a minute with the questions. Oh, here it comes back.
Okay, and now we continue to a question from Facebook from Jake, who's asking, hi, just out of the curiosity, my fiance and I will be interviewing in Manila. Since it's at a U.S. embassy, will the interview be American or Filipino? Okay, so yeah, I mean, obviously every embassy, they typically have people that are, from that country, but it's not guaranteed. I mean, you might see, actually an American person or an American Filipino person working there, so it's not a guarantee. It also seems like they do them in English or in your native language if they have the speakers there.
Yeah, I personally went to the interview with my current wife, who was then my fiance in Manila, and of course we've done thousands of them there since then. And what I can tell you is with these embassies, well, with really every embassy, most every embassy around the world, they will be staffed predominantly by locals. So most of the people who are doing the security outside and the checking, the pre-checks of your documents when you're getting into the, it is a process. You don't walk in directly for an interview and leave. You kind of go through some stations and pre-checking your documents and so on. Most of those people will be locals who will speak the local dialect. When you get into the little room, though, to do the actual interview, that will be a consular officer, which will be an American. Now, it could, Americans come in all nationalities, as we know. So it could be a Filipino American, could be who knows what. But there'll be a mix of people, and there is no requirement that you speak English for the interview or have great English. So there'll always be somebody around, whether it's Manila or anywhere else. There's always going to be somebody around the embassy who can help with the language if that's a problem. Okay, from Facebook, Hazel says, hey, I like that name, Hazel. Don't see that one too much anymore. Hazel says, what would change under the new public charge rule policy? Who would be affected? Okay, so who would be affected is the plain reading of it, and that's all we can go on because we have no history of how they're going to implement it. There's not been any guidance really issued. But our understanding of it, as it is plainly written, is if you're an alien only, this doesn't apply to sponsor. If you're an alien, meaning a non-U.S. citizen or green card holder, and you've used U.S. public benefits, not public benefits in your country, but U.S. public benefits, then you are going to face increased scrutiny because they may think, hey, you're just here, using public benefits, and you're going to be a drag on the taxpayer. So that seems to be the best of our ability to decipher the government speak. That seems to be who they're looking at. If you're an alien who's never worked a job or never worked in, kind of an official job or never made much money, that's not really going to be relevant as long as your sponsor has the income and resources to support you. And that's always been the case. And so, again, what I would say is I don't think most people need to worry about this public charge rule. I could be wrong. They could implement it very strictly because there is kind of a wild card statement in there. After it talks all about using public benefits, there is also kind of one out for a consular officer who might want to use or abuse it that says, if the consular officer thinks that you may in the future become a public charge. I don't know how they determine that, but there is that out. So I suppose a consular officer who had reservations or for whatever reason wanted to deny entry could claim that, hey, yeah, you've never used public benefits in the past, maybe you've never even been to the United States, but based on your history, we think you're coming to the U.S. and going to end up on public benefits. I suppose that could happen. Time will tell. Right now, it's understandable to be nervous about it, but unfortunately, we don't have any more information than the plain reading of the rule.
Okay, and we continue to YouTube. The question is, if I'm making $45,000 a year and petitioning for my wife and her 2 daughters, will this be above the 250% poverty guideline? So right now we don't have the table yet. I don't have it right here in front of me. I suggest that you call us just to verify if you're under that 250%. I know you are under the above the 125%. You're
yeah,
way
we've
over
got
that.
a calculator on our site, and it's hard to know all these numbers off the top of your head, but I mean, 45,000 is good. I can tell you that's at or above a great number of our applicants. So I think you're going to be okay. You know, the 250% is really just kind of a guideline to say, hey, if you're above this, you're in good shape. Don't even worry about it. Doesn't mean if you're below it that you're disqualified. The rule is still 125% or 100% for K1, but 125% for everybody else AOS. So that's still the rule. So if you're at 200%, you're fine. If you're at 130%, technically you should be fine. I think they're just trying to say, look, if you're over that, don't even think about it. If you're under it, just make sure your evidence is all together. And that's one of the things we can help you with, because we do so many, we get a lot of feedback from the government. We understand kind of what qualifies as good evidence of your finances and what doesn't. So that's where we can help you. But again, I think you're fine. There's other variables though. Do you have any children in your household already that you're taking care of and things like that? So it's hard to give that a real, simple answer. Okay, from YouTube, Caribbean Girl says, do I get my son SSN in the mail because we added RapidVisa and we signed my doc? Yeah, there's a question that asks, do you want to you do want us to go ahead and procure your Social Security card number for you? And we always recommend that you check that and say yes. And usually that will work okay, but if it doesn't, you may have to go down to your local office. It doesn't seem like it's been 100% foolproof, but for most people, yes, you'll get the Social Security card. But every city of 10,000 or more people, or somewhere in there, that's a guess. But what I'm trying to say is most cities of any size will have a Social Security office. It's a very easy thing to go down and get that Social Security card and number if you need to. So I wouldn't get too stressed about it if it doesn't show up, but it should. It should show up if you have checked that box on the form.
Okay, now we have a question from YouTube. Kazan is asking, do you help with the naturalization process too? I just got the visa thanks to you. Would I be eligible to apply? Is it 3 years after receiving the conditional residence or 3 years after the permanent residence? Well, congratulations on you receiving your permanent resident card. We do assist with the naturalization process. I'm assuming you are married, obviously, to a U.S. citizen. So it is 3 years after receiving your conditional permanent resident card. So if you're at 3 years or you're wanting to apply a little bit earlier, you can actually apply at the 2 years and 9 months mark. Give us a call and we'll be happy to assist you with this process as well.
Okay, from YouTube, Gabriel is asking, currently in the adjustment status phase, he's currently in adjustment status phase. I heard that there's a 20% chance that I and my wife will not have to attend the interview to get our green card. Is this true? I've never heard that 20% number. I don't know where that come from. You should count on having an interview. If you don't see how you came here. If you came on a K1 visa, many times you will not have an interview. If you came any other way, you almost certainly will have an interview. So if you didn't come on a K1, you might not have an interview. I can't tell you what the numbers are. In the past, it had been low. So maybe the 20% is a reasonable guess, right? These aren't numbers that are published, so nobody, I don't think, could know for certain. If somebody's made an assumption 20%, that might be right. Maybe even one of our people said it because it sounds reasonable. I'm just trying to make the point that we don't have exact numbers like from the government to say what your odds are. But if you didn't come on a K1, you almost certainly will have an interview. So there you go. And I wouldn't be afraid of the interview. We don't really hear of people. If you came on a K1 and you get an interview, we don't know of a case where anybody has ever failed or been denied at that interview. So it's really just a formality. You'll do a biometrics to get the photo and thumbprint that they're going to use on your green card and so on. But I wouldn't worry about it too much. Most people don't have any problem with that if you came on a K-1 because you've really already been vetted.
We continue on a question from YouTube. And Claydude is asking, is it true that the adjustment of status interview wants to see financial accounts in both my spouse and I's name? Every account I try to set up wants a social security number, which my spouse does not have yet. Okay, so yeah, at the adjustment of status interview, yeah, obviously they understand that, this person, and I'm assuming she came here on a K-1 or he came here on a K-1. Yeah, they understand that she recently arrived here in the U.S. You do not really have to prove your relationship at the adjustment of status interview. As Ben just mentioned, they just want to see, both of you there. They might ask you a few questions about your arrival, how your case is going, as we have heard before. But it's not really to prove your relationship since you just got married. And obviously, you are just gathering these documents. It is important for you to start gathering documents for your removal of conditions, which will happen in 2 years. As a result of the adjustment of status, your spouse will receive a 2-year conditional permanent resident card. So we highly suggest that you start, as soon as she gets her social security number, to start enrolling her or adding her in your bank accounts and your, utility bills. Anything that can help you prove that your relationship or your marriage is bona fide.
Yeah, and if you didn't come on a K-1, which means you're filing an I-130 concurrently with the adjustment status because you were already here in the U.S. for some reason, then in that case, yes, you're going to have to prove the relationship, but that's part of the I-130 technically, but you're doing this all together. So, but if you came in a K-1, you'll be fine. But it does. If there are any doubts by the consular officer, it does help to have as many things as you can in both of your names when you can get around the SSN. A person who's already been here on a student visa or something like that, if they had work authorization, they may already have a social security number or a tax ID, a TIN. So if they have those numbers, but if not, they understand that certainly. Okay, YouTube, Chris is asking, I met my fiance on a free dating page. We want to apply to K-1. I've got 2 years relationship. We've seen each other 7 times. Would it affect my process if dating site does not comply with IMBRA? Well, it's not disqualifying. Most dating sites are not, don't fall under the IMBRA classification, right? So that's International Marriage Broker Act. It basically says if you're an international marriage broker, you have, there's certain guidelines you have to follow, and what they're trying to do is avoid some of the abuses that have happened in the past, right, with these matchmaking type services. So typically, most online dating sites that we're aware of do not really fall under this IMBRA Act because they're not matchmaking, they're more of bulletin boards. You go there and you meet somebody, you're doing the matchmaking yourself and you're basically using their software, right? It would be IMBRA if there was somebody at that service who is sitting down and putting people together and making introductions. That's kind of the traditional definition of IMBRA. So most dating sites don't fall under this. Most dating sites that will have that somewhere in their terms and conditions that you can look up where they'll state that, and you can provide that information with your petition. So a majority of the petitions we do, and we do more K-1s than anybody in the country, the majority of them did meet on a dating site and don't have any problems. You have to address that. You have got to find the terms and conditions, and if you're working with us, we'll help you with that. But then you will go right through. So most people don't need to worry about it. You'll know if you used actual IMBRA. You set a dating website, so it doesn't sound like that's a problem for you.
And especially if it's free as well. All right, now we continue on Facebook with Issy asking, do I need substantial savings to bring my fiance here? I make good money, but I do not have anything substantial saved up in the bank. Okay, so yeah, if you meet the poverty guidelines, if you say you currently make a pretty good amount of money, yeah, you do not necessarily need to add your assets. So bank accounts or assets, real estate, any other assets might not need to be added if you meet these guidelines.
That's right. Even in form, it even says that the assets are optional if you don't meet the guideline, and it states something about, only complete this section if you don't meet the finances. So assets are difficult. I think that the government doesn't even usually want to fool with that if your income's good. So don't worry, and a bank account would be an asset. So no, there's no requirement that says you got to have X number of dollars in the bank. Now, if you don't have a strong job, but you do have a huge savings account, then that can work in your favor too. But your situation is the opposite, so I wouldn't worry about it. That's actually quite common. Okay, Michelle from Facebook says, after getting the Social Security card, can I apply for work even if I'm still waiting for my interview? The Social Security card alone does not allow you to work if you don't have a green card or an employment authorization document, an EAD they call it. So when you apply for the adjustment of status, you can at the same time submit a request for a work permit, and if you're using our service, we always do that. And with the idea being that they know it takes a while to get the green card, they know people need to work, and so you wait for that card. It's usually combined, they call it a combi card. It's usually combined with your advance parole, which is a travel permit, but not always. So once you get that work permit, then you can work. So Social Security number, Social Security card number alone doesn't let you work. And in fact, they'll generally say on them something about work authorized in conjunction with a work permit or EAD or something like that, if you've got a Social Security number and you're not a permanent resident. So the bottom line is, no, it takes more than just a Social Security card. When you go to work for an employer, you'll be required to complete a Form I-9, and it lists all the requirements. And one of them is a Social Security number, but beyond that, you're going to need either a work permit or a green card, or of course, just be a U.S. citizen already. So yes, you need more than just the Social Security number and card.
Okay, and now we continue on Facebook with a question from Michael, who's asking, I have a question regarding my N400 based on 3 years marriage. My taxes documents did not reflect on joint filed together, but I filed as marriage but separate. Will that be a problem? So if you obviously have a good explanation on why you filed marriage filing separately, and obviously you might want to provide additional documents. There's more documents that you can include besides the taxes, for example, bank statements and other documents. Then you should be fine. If you're a customer, I suggest that you contact us. We might have a good list of other good options for you for documents that you might want to include.
Right. People who file married but filing separately, generally speaking, and we're not tax experts, but generally speaking, you end up paying more taxes, right? So most people do not do that. So if you're doing that, married but filing separate, you're going to need to have a good reason for it, because obviously what they're looking for is fraud. They want to know that you didn't just get married to get a green card and a naturalization. So you're just going to need a good explanation. The income itself will be accepted because it's your household income, but you're going to need to be ready to explain why you're filing separate. Hopefully you're living together and you're just filing separate for some particular tax reason. And if there's a good explanation for it, I wouldn't worry about it at all. Now, if you're also living separately and filing separately, then that's probably going to raise a red flag. So again, you're going to need a good explanation for why that's going on. Okay, from YouTube, DC asks, my girlfriend and I met on a dating app. Yep, like most people. I cannot find anything on the site about international marriage broker. Will this be a problem? My girlfriend asked the same question here. Well, it may be. Generally, you do want to include something. I would try a search. Usually you can't get a hold of anybody on these apps, especially if they're free. You're not going to talk to anybody on a phone. But if you search through their site, there is a way you can search. You can do a Google search that only searches one website that can help you find stuff that's difficult to find. And it's basically you put in your search and then no space and a colon and then the domain name of the site, whatever it is. You can look that up, to figure out how to do it. But if you can figure out, or if you know how to do a search of just that site, that can help you find hidden, buried information. Our experience has been that most of these dating sites have been asked about this so often that they have posted it somewhere on their site. And so you're going to have to dig that out. We recommend, there's not a strict requirement that you send that in, but we have seen people have trouble when they don't indicate. You would think by now, after years of this, and we've been doing it for, this is our 11th year now, you would think after years and years that they would understand that most dating sites are not marriage brokers for some reason they've not learned that lesson yet, and they keep asking for it. So I'd go through the work of trying to dig it out if you can. Unless it's a brand new dating site, they've already been hounded about that very question, and they've posted that information. So I would try to find it. If all else fails and you absolutely can't find it anywhere, then just explain the site that it's just a dating site. They're not doing introductions, that you're not paying them to find you a bride or a husband. Just kind of explain how the site works, and maybe that would be enough, but generally a copy of terms and conditions or somewhere that mentions that would be better.
Right. Another way we have seen our customers trying to get this, on paper as proof that they're exempted from IMBRA is trying to contact them via email. So just maybe they have, as Ben said, you might not be able to contact them by phone, but there might be an email that you can contact for support, and you might get a reply back with the answer regarding IMBRA. Okay, now we continue with a question from Jeffrey, who's asking, how long is the adjustment of status process in 2020? So we've seen that it's been faster in the past years, but currently we're seeing around 10 to 12 months on average from start to finish. Some cases are much faster and some take a bit longer, but this is just a basic guideline to expect. So the notice of action, the first notice of action usually comes in 1 to 5 weeks. After that, you get the second notice of action, or NOA2, which is taking about 4 to 10 weeks. And then you will get the approval notice, which is the longest wait, which could be anywhere from 5 to 10 months. And then towards the end, obviously, the end result will be your green card, which usually comes in the mail with 1 to 4 weeks after that. So as always, timelines are always reward-looking. Neither RapidVisa nor the government can guarantee a timeline. The new public charge rule is rolling out this month, so we don't know the effect that this will have on timelines, but it's likely to prolong the processes even more. We suspect that cases with lower income and more issues with their case will see the longest delays. So we suggest that you get started with us as soon as possible and create your free account to get started.
Okay, from Facebook, Sonia is asking, we're filling out our application now for a spousal visa. I'm pregnant, and now an application will be submitted before the baby's born. Do we need to update our application after the baby's born as further proof of our bona fide relationship, or is showing sonogram photo and insurance? Okay, so two things here. Number one, yes, being pregnant can help establish that yes, we have a relationship. It's not foolproof, but everything like this helps, right? To show that, look, we're in love. This is a real relationship. We're even having a baby. That's great. The second thing that you didn't really ask that you need to worry about is if you're getting married and doing I-130, that baby needs their own separate I-130 application. So you send yours in, it gets approved, you're waiting for an interview, that's fine. When this baby's born, they can't just come with you. The baby needs their own application, which you can't do until the baby's born and you have a birth certificate. So you are going to have to figure out how you want to deal with that. If you are willing, and most people I would think are not, but if you're willing to have the baby and then come here, get your green card, which will come in the mail after you arrive, and then travel back to get the baby from mom or wherever you've left the baby, while you wait for the baby's petition, you could do that. Or you can wait in your country until you can get the baby's paperwork processed, but understand that you're starting all over. You're not going to shortcut the line. It's just as if you applied. So you got to figure out how you're going to deal with the immigrating baby. The baby doesn't just get to come with you. The baby needs their very own complete, no matter the age, even if they're days old, the baby needs a complete I-130 petition exactly like yours, with the filing fee and all the same document and the affidavit of support and the passport photo and all of this stuff. So that's your bigger concern. But your original question about, does that help show that a legitimate relationship? Yeah, sure it does. It's depending on what the embassy and all of that. We've seen cases where they wanted a statement from the spouse saying he understands that you're pregnant, right? Just to make sure everybody's on the up and up and so on. So you may see little things like that, but anything you have that shows that you have a real relationship, that's helpful to your case.
Okay, and now we continue to the question from Facebook from Christy, who's asking, is head of household okay to file for married CR1 if spouse is not in the USA yet? So as we said before, we are not tax experts. I highly suggest that you contact your tax preparer, a tax preparer expert that might tell you whether or not that is okay for with immigration. Obviously, right now she's not in the country, so they will understand if you don't have this taxes as married filing jointly to prove your bona fide marriage. Since she's not in the U.S. yet, that's something that's understandable. But again, I suggest that you contact your tax preparer for the tax rules regarding you being married by your spouse not being in the U.S.
Yeah, my basic understanding of taxes is that would not matter. That's just an election that has some tax advantages, and so that matters to the IRS. I doubt that it has any relevance to the USCIS, would be my answer. Okay, from YouTube, Sherry 786 Syed asks, we are married for 1.5 years. Congratulations. My spouse visited one time after we married and couldn't come again because of a foot surgery. Should I bring her medical record to the interview? Will it affect the case? Okay, so I get from this that your spouse is the U.S. citizen and petitioner and hasn't been able to visit there in quite a while. The good thing you have going for you said spouse, so I'm going to assume this is a spousal visa, and there's not a meeting requirement as far as time. That's with the K1. In the K1 visa, it can't be more than 2 years. When you file, it can't have been more than 2 years since you've physically seen each other. There is no such restriction with the CR1. It could be 5 years since you've seen each other. Now, however, having said that, obviously they're looking to make sure it's a legitimate relationship, and if it's been an extended period of time, they might question how legitimate it is if you haven't seen each other in a long time. 1.5 years is not that long, but sure, you want to have an explanation for it. What we tell people as far as bringing records to the interview, bring everything you have, bring everything you can carry. Most of it they probably won't look at, but it's better to have it with you so that if that becomes a question or concern of the pre-screener or the consular officer, you'll have it. You'll say, oh yeah, I've got that right here, and pull it out. So yes, anything you think might be relevant, including those medical records, bring it with you, and because that question may come up. Consular officer may ask, how come it's been 1.5 years since you've physically been together, and you'll have a ready answer for that. So yeah, I think you'll be fine though.
Okay, now we continue to YouTube. A person here is asking, I'm currently living in Vietnam, but I have been deported from the US a year ago after living in the US for 20 years. My fiance and I did a K1 visa and it got approved. Currently, I'm just waiting to gather all my documents, then schedule my interview. What are my chances of getting it approved at the interview after being deported? All we can tell you, obviously you got through the part of the petition, so
Right.
This K1 petition got approved already. You're now at the part of the National Visa Center to get just the actual K1 visa to be able to travel to the US. It's very likely that it will get approved. Now, with all these new changes going on, at the time that you adjust your status, this will be a question asked again, when you adjust your status, and it seems like deportations are affected.
And let me add to that, though. I think the critical thing is you said you were deported after being here for 20 years. Currently, if you overstay more than 6 months, less than a year, you're banned for reentry for 3 years. If you overstay more than a year, which you certainly did, you're banned for reentry for 10 years. And so, technically speaking, you can't come back for 10 years, even if you have approved petition. They'll say, hey, you're approved. Congratulations. Now wait 10 years and you can come. But there is a waiver for that, and the waiver, it's the form I-601 is called a 601 waiver, is the terminology if you're going to go research it. The approval rate, from what we understand, is pretty high, but we don't do those, and we're not attorneys, so we can't tell you how to proceed. But what we can tell you is you are subject in almost all cases if you've been here out of status. So, which is the part you don't really say. You say you were deported, but were you out of status? You can be in status and be completely legal and still be deported. That's the less common case, but it can happen. So if you were here out of status, in other words, you're illegal, without papers, without inspection, whatever terminology you want to use, you do have a 10-year ban in effect, but you can get that waived if you can show that you not being here would cause a hardship to a U.S. citizen, which is your sponsor. So you're probably going to need help with that. I would go look at that I-601 waiver. You can find it on the USCIS website under the forms page and read through it, see if it's something you want to tackle yourself. However, I would recommend you contact an attorney or somebody who specializes in waivers with your situation, because you may sit here and wait a year to get through this whole process only to find out you're subject to a ban when you could have already got your waiver in the system, had it in the queue to get adjudicated. So, it's a tricky thing. The funny thing is, it seems counterintuitive to us. You can submit these things and get them approved, and then they'll say you're approved, but now you have to wait. Similar thing works with immigrant visas. You can petition your sister, for example, and they'll say, okay, great, here's your approval of your I-130, now wait in the queue, and you wait 10 years if it's from someplace like the Philippines. So just because you're approved doesn't mean you're coming right away. You still probably almost certainly have a ban, a 10-year ban in effect that you're going to have to overcome. And the other thing, again, you didn't mention was, if you were deported due to some kind of criminal activity, you may well not get to come back at all. So I'm going to, again, recommend that you contact an immigration attorney and find out what your odds are. I mean, there's a reason. If you're only deported because you overstayed, that's one thing, and that you might be able to overcome that with a waiver. But if you were deported due to some criminal activity, then maybe you might have a tough road to climb, and you definitely ought to be talking to an attorney. Okay, YouTube, Beta Life Records. I met my wife on a dating app. We got married the first time we met. Might that be an issue? No, that's not an issue. You know, a lot of the relationships that we do, and we've done over 55,000 of these, certainly more than anybody else we know of. A lot of the relationships, the courtship period is short. And the reason for that is because it's remote. I mean, it's hard to have a long, slow, take your time engagement period when you're half a world away from each other. So it's very common that people have a short engagement or dating period and then get married. So no, that won't disqualify you. Now, always the issue is, does this look like a legit relationship? So if you don't have the history, yeah, you're going to have a little more work to do to prove to the consular officer that this is in fact legit when it's so short. But it can be done, and we see it done all the time. So to flip that around, I would say is what we don't see is we don't see denials where the consular officer says this relationship's too short, so we're denying it. We've never seen that happen. It's always, you didn't prove it, this was a legitimate relationship, so that's what you got to prove. So you're just gonna have to do a little extra work to make sure you got all of the traditional things we recommend to show the relationship. You know, emails, chat logs, photographs together, how you met, you know, your how long you were there. You know, you're just gonna have to detail it all out. If you've had one visit, although you didn't say you only been there or visit each other one time, you say you got married as soon as you got there. But anyway, just make sure you got a solid package. That's something we can help you with if you're using us, but it's certainly not going to disqualify you.
Okay, and we continue now on our YouTube. A question from Omar and Kate Aviles. They're asking, our case is at the NVC stage. There was a typo with my daughter's first name, and I tried to call the NVC office, but I couldn't get in contact with an officer. What do you recommend? So yeah, we've heard it's very difficult to actually speak to someone at the NVC. You know, all I could say is keep trying to contact them by phone. There's also other ways to contact them. There's a form online that you can fill out, and we've heard pretty positive results from that. You know, they actually do get back to you within 3-4 business days in that week. So if you are a customer, excuse me, I recommend that you contact us, and we can give you that information, that link, so you can try to contact them electronically.
Okay, from Facebook, Tina is asking, as a RapidVisa customer, if I send in proof of bona fide marriage, such as pictures, chats, etc., does RapidVisa send this in with a packet to USCIS, or should I send it? Well, yes. Whatever you send to us in the way of supporting evidence, we are going to package up and organize and make sure it's properly labeled, and we are going to submit it with your petition. So yes, if you send it to us, unless it's completely irrelevant, you know, a picture of your neighbor and you're not in it or something, unless it's completely irrelevant, we are going to forward that on with your package. Okay, it looks like that brings us to the end of our hour. As always, these times go by very quick. Once again, I'll remind you, we're not attorneys, we're not a law firm, we're a document prep company, licensed, registered, bonded here in the state of Nevada. We've done over 55,000 of these. We're happy to help, but don't make important life-changing decisions based on some video you saw on YouTube. And thanks for joining us. We need to select our winner. Okay, they've got it here for me. Our winner is, this is the winner of $100 Rapid Visa credit, Christy Boscanio. Sorry if I didn't get that last name right. Congratulations. Just contact us. We'll have your name, and we'll help you figure out what to do with that. And check out our channel, see if there's other questions. You can find us on Facebook, on YouTube, and everywhere else, all social media. And of course, we have our website, and we have a live chat. So don't think that you've lost your opportunity if you didn't get in during this hour. We are very easy to get a hold of. You'll see our ads everywhere. You can find our website, RapidVisa.com. Thank you for joining us today, and we look forward to seeing you next time.
Thank you.
Thank you for joining us today. We apologize if we didn't have time to answer all your questions. However, you can always contact us by phone or chat to answer your questions. We want to remind you that Rapid Visa is not a law firm and is not licensed to practice law in any state. The hosts of this show are not attorneys. Rapid Visa is a document preparation firm licensed and bonded in the state of Nevada. If you need help with your immigration petition, check us out. We've helped over 30,000 customers from 180 countries apply successfully. Check out our testimonial library at RapidVisa.com, where we have over 1,000 photo testimonials from actual customers describing their immigration journey with Rapid Visa. There's no cost or obligation to create your Rapid Visa account. You can create your free account at RapidVisa.com/free. Be sure to like and follow us on Facebook to be notified of future live streams. Thank you, and see you next time.